An uncontested divorce in California isn't a shortcut process with fewer forms. It's the same process as a contested one, just without disputes to resolve along the way. Here's the full sequence, start to finish. Step 1. Confirm residency and grounds. Before filing anything, at least one spouse generally needs to have lived in California for 6 months and in the county where you plan to file for 3 months. California is also a no-fault state, so the only ground you need is irreconcilable differences. Neither spouse has to prove wrongdoing. Step 2. Choose your filing path. If you and your spouse already agree on everything, you generally have 2 structural options. The traditional path, where one spouse files as petitioner and the other is served and responds as respondent. Or, since January 1, 2026, the Joint Petition, Form FL-700, where both spouses file together with no service and no response deadline, since the petition is deemed served the moment it's filed. Some short marriages with no children and limited property may also qualify for the older summary dissolution process on Form FL-800, which is worth checking before committing to either path. Step 3. Start the case. On the traditional path, the petitioner files Form FL-100, the petition, stating the case type, date of marriage and separation, and what's being requested, along with Form FL-110, the summons. If you're filing jointly, both spouses sign and file Form FL-700 together, along with FL-710, the summons for joint petitions. Step 4. Serve your spouse and file proof of service. This step only applies to the traditional path. An adult who isn't a party to the case delivers copies of FL-100 and FL-110 to the respondent, then completes and signs Form FL-115, proof of service, which gets filed with the court. The date recorded here matters beyond formality. It's the date California's mandatory 6-month waiting period begins and the date the respondent's 30-day response clock starts. Joint petition filers skip this step entirely, since there's no respondent to serve. Step 5. The response, or the default path. The respondent generally has 30 days from service to file Form FL-120, the response, which in an uncontested case typically just confirms the facts and terms already agreed to. If the respondent doesn't file a formal response, that doesn't automatically derail an agreed case. Once the 30 days pass, the petitioner can file Form FL-165, request to enter default, and if there's a signed written agreement, submit it alongside the default so the judgment reflects those agreed terms. Step 6. Exchange financial disclosures. Every California divorce, uncontested or not, requires both spouses to exchange disclosures, generally within 60 days. Form FL-140, the Declaration of Disclosure, Form FL-150, the Income and Expense Declaration, and either Form FL-142, Schedule of Assets and Debts, or the simplified Form FL-160, Property Declaration. 2 years of tax returns generally go along with these. Agreement between spouses makes this step move faster in practice, but it doesn't remove the requirement itself. Step 7. Put your agreement in writing. Once disclosures are exchanged, an uncontested case needs the actual terms on paper, how property and debts are divided, support, if any, and a custody and visitation arrangement if you have children. This written agreement is what your judgment paperwork will ultimately reflect. Step 8. Wait out the 6-month period. California requires a mandatory 6-month waiting period before any divorce can be finalized. That clock starts at the date of service in the traditional path, or the date of filing in a joint petition case, and it can't be shortened no matter how quickly the rest of your paperwork is ready. Use this time to finish disclosures and finalize your agreement, so you're ready to submit the moment the waiting period ends. Step 9. Submit your judgment paperwork. Once disclosures are complete and the waiting period has run, the final stage generally includes Form FL-170, the Declaration for Default or Uncontested Dissolution, used to support the judgment request, Form FL-180, the Proposed Judgment, with your written agreement attached, and Form FL-190, Notice of Entry of Judgment, which the clerk uses to notify both spouses once the judge signs. Every filing step along the way generally carries its own court fee in the $435 to $450 range, so a case with both a petition and a response can involve two fees. If any of that is a barrier, Form FW001 can be filed at any stage to ask the court to waive or reduce it. An uncontested divorce is really won or lost on paperwork discipline, the right form at the right stage, with consistent information carried across every filing. Virdix's guided questionnaire is built around exactly this sequence, from FL100 through FL190, so your names, dates, and case number carry through correctly, and your disclosures stay on schedule. Virdix is a document preparation service, not a law firm, so this is not legal advice. And for advice about your specific situation, talk to a licensed attorney. You can start at virdix.co.